Good evening. We're going to go ahead and get started. We're here tonight for the public participation hearing, and we have court reporters here, so we are on the record. We're here tonight for the public participation hearing in the order instituting investigation on the Commission's own motion into the rates, operations, practices, services, and facilities of Southern California Edison Company and San Diego Gas and Electric Company associated with the San Onofre Generating Station Units 2 and 3. My name is... Can't hear you. You can't. Is that better? Yes. All right. My name is Darcy Hauk. I'm the assigned administrative law judge for this proceeding. To my right is President Michael Picker of the California Public Utilities Commission. He's the assigned commissioner for the proceeding. The agenda for tonight's hearing will be, I will first open it up for opening statements from President Picker. I'll give a brief background of the proceeding and purposes for the public participation hearing. Then Southern California Edison Company will be giving a brief presentation outlining the 2018 settlement on behalf of the settling parties. We will take comments from any elected officials that may be here. We will take public comment, and then we will adjourn. We will not be taking any action this evening. We are here to listen to the public. So I'm going to now turn the microphone over to President Picker.
Thank you. My role is different than that of the judge, who really maintains the overall course of the proceeding, running the hearings, and keeping the process in order. She develops all the actions that result in a robust record, which is a published document that we use to actually make our decisions. My role is really, as assigned commissioner, has been to focus on the scoping. As we open up different phases of a proceeding, we'll lay out the questions that we're going to focus on in each part of it. This has been a very long and very contentious process. It's had 3 assigned commissioners, 2 of whom have retired, and several judges. The judges, again, going to collate the record. She'll compare to the scoping. She'll look at all the arguments that people have made and all the evidence they've presented. She'll prepare a proposed decision. Usually we, as assigned commissioners, agree with the judge. If for some reason we don't, then we prepare an alternate proposed decision. Now, I don't so far expect to see that happen here. But you know, there's always the chance that we may disagree on some fine points. We're really nearing the close of this very long process, and tonight this is an opportunity for us to hear from the public, not our staff, not the formal parties, people who've actually applied to submit evidence to us and cross-examine each other. We're really here to hear from the public, people who haven't really had the same kind of opportunity to speak to the commissioners, to the judges. So I'll be quiet for most of the rest of the evening and just listen. So thank you for coming. I appreciate you guys spending part of your evening with
us. So thank you. For those not familiar with how the California Public Utilities Commission performs its responsibilities, one of the key responsibilities of the Commission is to evaluate rates that are being charged to ratepayers and determine whether they're reasonable. This proceeding was open to investigate the costs associated with the premature closure of SONS Units 2 and 3. And as President Picker just indicated, it's been a very long process. I'm just going to touch on a couple of key dates, and then we will move forward with tonight's hearing, and again, the purpose is to hear from the public. So the SONS OII, this investigation, was opened in October of 2012. A subset of the parties had reached a settlement agreement that the Commission adopted a modified version of in November of 2014. In May of 2016, the record in the proceeding was reopened related to information that came about after the decision to adopt the modified settlement came about regarding some unnoticed ex parte communications. The 2 of the parties in the proceeding filed petitions to modify. In December of 2016, there was a joint ruling issued with the then assigned commissioner and myself that asked the parties to meet and confer and see if they could come to modifications on the settlement with the full and complete record that was before us. In August, the parties filed a status update with the commission saying that a settlement could not be reached. There was a status conference in November looking at going forward with hearings. In January of this year, 2018, Southern California Edison Company, San Diego Gas and Electric Company, the Alliance for Nuclear Responsibility, California Large Energy Consumers Association, California State University, Citizens Oversight, DBA Coalition to Decommission San Onofre, Coalition of California Utility Employees, Direct Access Customer Coalition, Ruth Hendricks, Office of Ratepayer Advocates, and the Utility Reform Network and Women's Energy Matters filed a motion requesting that the commission adopt the proposed settlement that you're going to hear more about this evening, and those parties will be referred to as the settling parties. A number of representatives from those different groups are here today. I'm going to ask that they raise their hand and show where they're sitting. So again, we're not going to be taking questions or doing a back and forth dialogue, but those are the settling parties, and if after the hearing anyone has any questions or wants to talk to those entities, they've identified themselves. There is also an additional party that was given limited party status, Public Watchdogs, and I'm not sure if there's a representative from them here. There is. So they've just identified themselves. They are not in support of the settlement. The parties have briefed outstanding issues and have submitted additional information to the commission in the form of a stipulation of undisputed facts. Therefore, evidentiary hearings are not necessary at this time. And this public hearing will be part of the official record, and the purpose is, again, to receive your comments regarding the issues that we're going to be deciding as to the settlement that's currently before us. As I mentioned, the Office of Ratepayer Advocates is a party to this settlement. We want to make clear that they are not commission staff. They do not advise us. They are an independent party representing ratepayers. So Southern California Edison, on behalf of the settling parties, is going to provide a brief presentation in just a moment. We also have representatives from the Commission's Public Advisor's Office in the back that I believe those that have requested to speak signed up with. If you have questions about providing further comment or want additional information about the proceeding, please talk with the representatives from the Public Advisor's Office, and they'll be able to direct you in the right direction on how to submit those comments or get the information that you would like. There's a court reporter here to make a record of your comments. A copy of the transcript from tonight's hearing is going to be part of the official record in the proceeding and made available to both myself and President Picker, as well as other commissioners. For those of you not familiar with the Commission's procedures, parties present testimony, evidence supporting their position in the proceeding, or they can reach a settlement, as the majority of the parties here have in this case, that resolves one or more of the issues. Because we have a settlement that's before us that we need to decide on, there will not be evidentiary hearings. At the conclusion of the proceedings, the assigned judge will prepare a proposed decision, as President Picker described, and consider how to move forward with recommendations to the full commission. The public participation hearing is an opportunity for stakeholders and ratepayers to provide the commission with information useful to reaching conclusions and making decisions. And the primary purpose of the hearing tonight, again, is to hear from you, the public. So before we get into the portion of the hearing where we're going to hear from public speakers, I'd like to introduce Mr. Ronald O. Nichols, President of Southern California Edison Company, and he's going to provide a brief overview of the settlement. And President Picker and I are going to move over here so we're not in the way, and we can also see the presentation.
Well, thank you, Judge Houck, President Picker, members of the public, I will provide just an overview of the proposed 2018 settlement and a very high-level comparison of the differences from the 2014 settlement associated with the allocation of costs for the closed San Onofre nuclear generating station, or SOMS. There are copies back on the Edison table back there of these slides. If any members would like to take those with them, we'll make those available to you. Judge Howe gave a summary of who the signatories are of the settlement agreement. Won't repeat them up here. They're up on the slides. Those items, note that in addition to the two investor-owned utilities, Southern California Edison and San Diego Gas and Electric, both the coalition, they and the Coalition of the California Utility Employees, or CUE, the Office of Ratepayer Advocates, or ORA, and the Utility Reform Network, TURN, were also parties to the original 2014 settlement, as was Friends of the Earth. They did not, however, Friends of the Earth did not sign the 2018. They were not a party to the 2018 settlement. At a high level, the key terms of the 2018 settlement comes to cessation of the of the collections from customers. The utilities will stop the collections from rates when the remaining investment balance is $775 million, and that we refer to that a couple of times. We'll refer to that here as the cessation date. We estimate that that will occur on December 19th, 2017. Yes, that's last year. But this will depend on how the Commission resolves a related issue, which is then actually a different proceeding. And if that didn't resolve in that fashion, the cessation date could move to April 21st, 2018. The utilities will refund customers the amounts collected after that cessation date, since obviously either one of those dates have already passed. The utilities will retain all the amounts that we have collected after the cessation date. Refund, and then on the nuclear fuel, the utilities will not recover nuclear fuel in any rates after the cessation date, but the utilities will retain all the amounts that are received from the future sale of that nuclear fuel. One of the other provisions relates to Mitsubishi. Mitsubishi was sued by the SOMS co-owners. They were the supplier of the defective steam generators for the plant. The 2014 settlement provided for the utilities to credit the customers 50% of the net recovery from Mitsubishi after deducting legal fees. But under the new settlement, no further sharing of recoveries from Mitsubishi. One of the other provisions relates to greenhouse gas emissions. The utilities will contribute a total of $12.5 million to support research by the California State University, and that research covers issues related to development of technologies to either reduce, avoid, or mitigate greenhouse gas, GHG emissions, and also to integrate renewable energy resources in both rural and or disadvantaged communities. Now, one quick word about decommissioning. The 2018 settlement does not affect the decommissioning costs or the plans associated with the plant. Those are provided for from a nuclear decommissioning trust fund, not part of the settlement itself. There are some other agreements we won't go into the details of right now, but there's an agreement between Southern California Edison Company and San Diego Gas and Electric Company. Their shareholders, referred to as the shareholder agreement. There's also an agreement to resolve Citizens Oversight, Inc. et al. Versus PUC et al. In a federal court lawsuit. We refer to that as the federal court agreement. And then there's a shareholder agreement both the shareholder agreement and this federal court agreement that I just referred to are referenced in the proposed 2018 settlement agreement. That's why I'm mentioning them here. They are available on the CPUC website, and the docket card for that proceeding shown up here is 1.12-10-013. Talk briefly about the total costs and then go to a bar chart here in just a moment on the allocation of those. The two utilities did seek to recover overall approximately $5.5 billion in the total SONGS costs on the closure. And the next slide will get into the division of the shares of the cost between both shareholders and customers under the 2014 agreement and also under the 2018 agreement as a percentage of that $5.5 billion. So this slide shows, here on the left is the 2014 settlement agreement at a high level. The bars show at the bottom dollars that were provided from other sources for insurance and nuclear decommissioning trust and Department of Energy credits that were provided into the total. And then the amount for shareholders of the utilities, and then the top bar was the customer share. That was the bar to the left. You move to the right is the 2018 settlement, which shows that same groupings and the change in that allocation between the two different settlements. Talk briefly about the rate impacts associated with the settlement agreement. Southern California Edison and San Diego Gas and Electric customers will no longer pay for $775 million in SONGS investments that had not yet been recovered back as of the cessation date. And that comes down to $624 million for Southern California Edison and $151 million for San Diego Gas and Electric. So SCE customers' portion of that total reduction becomes down worth to about $68 per residential customer over the next 4 years. That similar number for SDG&E customers' portion will be roughly $64 per residential customer over the next 4 years. And just for clarity, both the utilities will provide a refund for any amounts that are collected after the cessation date, because we are still collecting today in rates. Since that date goes back previously, we will provide a refund of the difference upon approval of this settlement. And that summarizes my comments.
We'll now hear from the public, and I've been provided a list of those that have signed up. So again, I'm going to remind the speakers this evening that court reporter is taking down everything that's being said for the official record in the proceedings. So when you come to the podium, if you could repeat your name and spell the last name for the court reporters, that would be appreciated. And again, try and speak into the microphone and clearly so that the court reporters can take down everything that you're saying. The first speaker that we have is Penny Maynard.
My name is Penny Maynard. I'm representing the St. Clemente Chamber of Commerce. The Chamber supports the revised settlement agreement. This revision is a result of extensive efforts over many months by all parties to reach an amicable agreement. Let us move forward. Please move forward and look to a brighter future. Thank you.
Thank you. Our second speaker is Byron Shinyama.
Good evening, I'm Byron Shinyama, S-H-I-N-Y-A-M-A, and I'm the Director of Community Development Services of OCAPCA, which stands for the Orange County Asian Pacific Islander Community Alliance. We too are also in favor of the settlement. OCAPCA represents we serve over 30,000 people a year all throughout Orange County, and I think the settlement would be a good move forward, and hopefully the CPUC will approve the settlement.
Thank you. Our third speaker is Ken Berg.
I'm Ken Berg, B-E-R-G. My wife and I live in Mission Viejo, 20 miles northwest of San Onofre. And I respectfully request the Commission to reject the proposed settlement because it prevents access to information allowing informed commentary by ratepayers for an expedited cleanup of songs, materials, and apparatus at no cost to the ratepayers. Period. That was one sentence compared to the 1,000 pages that the commissioners from San Francisco prepared for us. We're going in the wrong direction if we don't look at this properly, and so far there's been nothing that has come in any of the documentation I've seen since January 30th that says we are going in the right direction. I did say period, so I'm ended, but I'll take any questions that you may have. Thank you.
Thank you. Our next speaker is William Kaysen.
My name is William Clausen, K-L-A-S-S-E-N. Thank you, President Picker and Judge Hawk, for your participation and allowing us to speak to you tonight. I'm a longtime resident of Irvine and customer of Southern California Edison, and ask that the Commission stand in support of the settlement agreement that has been reached by all the parties that were listed earlier. I also have an interest in an office building in Irvine, which is a customer of Southern California Edison as well, and would expect that through the efforts of the agreement that we would see our rates go down just slightly, and we appreciate your approval of that settlement. Thank you.
Thank you. Our next speaker is Ari Goldberg.
My name is Ari Goldberg, G-O-L-D-B-E-R-G. I'm a business owner in Orange County, also resident and consumer of Southern California Edison, and a ratepayer. I requested the PUC approve the San Onofre settlement. It seemed like it took over a year to negotiate. Included all the interested parties, including the main players, which were Edison, Southern California Edison, as well as San Diego Gas and Electric, and of course all the interested consumer parties. It seems that they are all in full agreement that the settlement is fair to all parties. It's quite important that it will save us, the ratepayers, $775 million approximately, and would be a good thing for everybody. Thank you very much.
Thank you. The next speaker is Jane Clausen.
My name is Jane Clausen, K-L-A-S-S-E-N, and I'm here to encourage the CPUC to approve the San Onofre settlement. The settlement was agreed upon by all the parties, and it was negotiated for more than a year by an independent mediator who presided over the negotiations. The negotiations included all of the parties. No one was excluded. Agreeing to the settlement are consumer groups, ratepayer advocates, Southern California Edison, and San Diego Gas and Electric. all these groups agree the settlement is fair. To achieve consensus among that many groups is amazing and further shows the fairness of the settlement. Please support the fair side group and please approve the settlement. And thank you for your time.
The next speaker is Ziki, and is it Kieran?
Good evening. I'm a 46-year Southern California resident. So I've been paying Edison rates for 46 years.
Excuse me, sir, can you spell your last name for the court reporter, please?
Kayran. And I'm a commercial customer for 28 years. Right out of school, I went to work for Bechtel Incorporated, and then subsequently I worked for Bechtel Power Corporation. And I was involved in all three SONGS plants: seismic reevaluation of Unit 1 and the design of Units 2 and 3. It's sad to see them go. However, I'm going to talk about two things. One is, I'm urging the Commission to approve the settlement. It was an open discussion. It included all the parties that are affected by this closure. It wasn't done in secrecy. Now, the other thing I would like to mention, I don't know if I didn't hear you correctly, Judge, but the ex parte communication took place before the CPUC voted on the initial settlement, because that happened in March 2013 in Warsaw, Poland, with President Peavy. So when he voted on that decision, he knew that ex parte communication took place. And Commissioner Flory was over there too, so I want the record to reflect that. Thank you.
Norman Vu.
Hello, my name is Norman Vu. I'm a resident of Irvine. I also work for a small minority women-owned business. Personally, I already pay over $400 per month for my electricity bill from Southern California Edison. I know our company already pays over $1,000 per month for electricity, which is already high. By approving this settlement, you'd be making a positive difference to the millions of people and businesses of Southern California. In this day and age, every dollar counts, especially for recent graduates, young families, small businesses just starting out, and also the elderly and retired. This settlement was negotiated for a very long time by all parties, and in the end, all parties came to a consensus, which, as you heard from previous speakers, is a pretty remarkable thing. This settlement is also good for all ratepayers involved, saving, as you heard also, probably over $775 million. So I ask that you, the CPUC, please approve this settlement. Thank you.
Madge Torres.
Hello, my name is Madge Torres. This settlement was done in the open, and the result is we're going to save money in our home. And that's important to me and to all the people that are struggling now with the wages being as low as they are. We need to have a break when we can get it, and I appreciate the efforts of all the parties involved to come to consensus and to agree to save the ratepayers money rather than the shareholders. So please approve this agreement on behalf of the people that live here.
Arturo Torres?
Hello, my name is Arthur Torres, Torres. Please pass the assignment. Please pass whatever. It'll save me money.
Kelly Speed?
Hi, my name is Kelly Speeg, and it's S-P-E-E-G. And thank you for allowing me to talk tonight. What I'd like to share is that the evidence that shows Edison was 100% responsible for the failure of the steam generators was never made public. Given the steam generators were not used and not useful, it is contrary to law for the public to pay Edison for those steam generators. Any settlement that includes Edison being reimbursed for the construction of the failed steam generators is unlawful. And I request that this matter be followed to the letter of the law. Thank you.
Thank you. Bobby McDonald?
Good afternoon, Bobby McDonald, McDonald. I'm president of the Black Chamber of Commerce of Orange County. I want to thank you for being here and allowing us to speak during these public comments. We feel the settlement is good for the ratepayers, and that includes the thousands of small businesses like members of our Black Chamber and all the other multicultural chambers and city chambers. In addition to this $775 million in this revised settlement, we appreciate that more than $2 billion has already been returned to customers under the 2014 settlement, which ensured that customers did not pay for the Mitsubishi faulty steam generators. So the Orange County Black Chamber of Commerce urges the Commission to approve this settlement agreement. We need to move forward and focus on our efforts on building our future infrastructure, creating new jobs, and growing our economy. Thank you.
Thank you. Are there any other members of the public here today that wish to make a comment that have not signed up to speak?
Hi, my name is Michelle Gomez, and I am here to say that I support this decision and I support the settlement. I am currently running for County Board of Supervisors in District 5 of San Diego County, and it would be beneficial to our residents if this were to pass. Thank you.
So thank you everyone for showing up this evening. We know this process has been long, and as President Picker stated earlier, we hope it comes to a conclusion soon. The Commission thanks everyone for their participation this evening, and with that, we will close the hearing.